You want us?
Okay. Good afternoon, everyone. Good afternoon, David. Thank you for all coming on for this webinar. Interesting topic, residential tenancies. We have a lot of, I'm sure we'll have a lot of questions at the end of the session, David, because I know it's a very, very complicated topic, and people are faced with a lot of issues. I don't know if Victoria signed in or not, but just her and I were chatting about this a couple of days ago. And the amount of sorry, issues people are faced with this. Oh, great. Victoria's on as well. So I'm very excited to hear what David has to say, and then maybe we can throw out our questions and David can answer them. So over to you, David.
Okay. Thank you, Sabiha, and good afternoon, everybody. Thanks for joining in on today's webinar. So what I hope to accomplish in the next hour or so is to give you some guidance in your role as a realtor, whether you're helping a client buy a property that's subject to a tenancy, or you're selling a property that might be subject to a tenancy, and just give you some general information about that, because there's issues that have to be dealt with, and obviously you gotta be thinking of these things up front and have the appropriate strategies in place for it. So let's get going on it. I'm going to skip through a couple of our introductory slides because I think most of you are aware of it, and we're going to playing a little bit of catch up. So we're going to just skip through a couple of these slides so I can get through everything. But this is a topic that David and I have talked about in podcasts before. Please tune into our podcasts, look us up, check out the table of contents, find what's of interest to you, give us some feedback, suggestions for new topics, etc. Welcome at all times. And so check it out. So let's start with, you're selling a property that has a tenant, selling a tenanted property. So no problem with someone selling a property that's subject to a tenant. The issue is, do we want to sell it vacant, get the tenant out, or are we going to sell it subject to the tenancy? Whoever's going to buy it has to assume the tenancy. So the Residential Tenancy Act, RTA is the short form that we've got in here. You're going to see that pop up a few times, and that's the legislation that governs residential tenancies. And our focus, by the way, Teddy, we're talking about residential tenancies. It's got nothing to do with commercial tenancies. It's a whole different thing. We're talking about residential tenancies. So there isn't a requirement under the Residential Tenancy Act to disclose a potential sale to the actual tenants that are living in the property. But from a practical point of view, it's usually beneficial for there to be that disclosure. If you're selling a property that's subject to a tenant, you're generally going to need the cooperation of that tenant in order to sell the property. So why not let them know? Why not disclose that to them? So you can disclose it by sending a tenant a notice of intention to sell the property. And then if you do sell the property, or the property is sold, a notice should definitely be given to the tenant after the fact, saying, here, we're notifying the property's been sold, and here's the name of your new landlord, and direct all future payments to this new landlord. And I'll go through that in a little more detail later on, but there should always be a notice of provided after a closing like that. But I always think it's good to communicate with the tenant. You're going to need cooperation of a tenant because there's going to be showings. There might be some staging done. There might be requirements for inspections. There might be requirement for an appraiser to get in there. You're generally going to need some cooperation of a tenant. So why not deal with it up front, set it up, and get some cooperation? The other thing is, oftentimes the tenant could be a likely buyer or a potential buyer. They know the property, they're living in the property, they've been probably helping to keep the property in good shape. maybe they're going to be interested. So why not communicate with the tenant early on? And that way you're avoiding conflicts and avoiding a tenant denying access for showings or for appraisals or inspections or things like that. So now when you're marketing the property and it's going to be subject to a tenancy, you should always be including the details of that tenancy, of that written lease, or whether it's a written lease or whether it's gone to month, doesn't matter. You should be specifying what the details are, because you really want whoever's buying it to assume all those obligations. There's no advantage to not disclosing something. So you should be including the rental income, the expiry date of the lease, any other relevant or pertinent information on the lease. Like disclosure never hurts you. So you should include that. Now, we're selling a tenanted property. Let's just go through some scenarios. One is that you're selling it and the buyer is going to assume the existing lease. If that's the intention of the seller, make sure it's clearly described that way in the agreement of purchase and sale, that the seller is not going to be providing vacant possession. Okay, the standard printed form agreement of purchase and sale says that vacant possession will be provided on closing unless it's otherwise specified somewhere in the agreement of purchase and sale. So if the intention is that vacant possession is not going to be provided because there's going to be a tenant in there on closing, and you want the buyer to assume that tenancy, make sure it's clearly set out in a schedule to the agreement of purchase and sale that the buyer is going to be assuming the existing lease on closing. And it's good to have either a copy of the lease attached to the schedule or a summary of the basic lease terms for the tenancy that they're going to be assuming. And if there's more than one tenant in the place, oftentimes there is, even in residential properties, there might be someone in the main floor, there might be another tenant in the basement, or maybe there's a few different floors. Then each one should be described and included in a schedule to the agreement of purchase and sale. Now, so that's your selling, and it's going to be subject to a tenant and a tenant's going to be assumed. So you're going to deal with that. The other scenario is the intention is to sell a property but provide vacant possession. So now we have a tenant in there, but we want to provide vacant possession. So how are we going to deal with that? So if there's a fixed term lease that hasn't expired, the tenant doesn't have to leave. The tenant has rights. The tenant can stay there. So the new buyer, whoever's going to buy this property, can't require the tenant to leave until the end of the lease, and cannot ask the seller who's trying to sell the property to evict the tenant on the buyer's behalf. So the buyer would have to assume the fixed term lease until the expiry. And then if the buyer, who's now going to be the new owner, or the buyer's family member plans to move in at the end of that lease term, then they can give 60 days notice to provide, 6 days prior to the expiry of the lease term, they can provide the 60 days notice, which will be done pursuant to a form N12, which is the notice to end your tenancy because the landlord, a purchaser, family member requires the rental unit. That's for their own purpose. And the termination date on that N12 has to coincide with the end of the original fixed term lease. You have to specify the end of the fixed term lease, and you've got to give 60 days notice for that. Now, it should go without saying, but I'm going to say it anyways, that it has to be bona fide. Okay? A buyer can't give that form N12 unless there's a real intention to move in, and it has to be by the buyer who's going to be the landlord, or sorry, the purchaser who's going to be assuming this property. It's got to be that purchaser, or it's got to be a family member, and you'd have to justify and have evidence to show that. It has to be real. Now, it's always open for a seller to negotiate and come to terms with a tenant prior to the sale to move out. That happens all the time. Usually there'll be some monetary incentive that'll be required to do that because the tenant has the right to stay. Tenant can say, no, it's not convenient for me. My lease isn't up till the end of June. I don't care if you've got a closing date that's the end of May. I'm entitled to stay for that month. I don't want to leave earlier. I'm going to be inconvenienced, blah, blah, blah. If there's enough time, then there could be a negotiation with that tenant and say, look, I want to make it worth your while to leave at the end of May instead of the end of June. We'll cover you for your moving costs. We'll pay we'll waive a month's rent or whatever it is. And if there's enough lead time for they can get out, then sometimes you can make a mutually beneficial agreement with the tenant to move out earlier. But remember, the tenant has rights, and any of you that have dealt with residential tenancies before, it's very difficult to get rid of a tenant, even a tenant that's in default. And here we're assuming there is no default. Tenant has the right to stay, but it's still open to the parties to agree. And if you're going to agree, you got to make sure you agree in writing. And if there is an agreement, then there's a form to be completed, the N11 form, which is an agreement to end the tenancy. And it's going to have to be signed by the tenant and the landlord. And that'll set out, the parties agreed that the tenant will leave on May 31st, if that's what it says. Okay. Now, if that's what it says, and then the tenant doesn't leave on May 31st, the landlord has the right to go to the tribunal, to the residential landlord and tenant tribunal, to seek an order from the tribunal requiring the tenant to move out, because all you got to do is show up. Well, you got to get in there. There's always a timing issue, but you're going to say, here's the N11 that was signed by the tenant and the landlord. He agreed to leave May 31st. He's not out. I need an order to get him out. So now you can't require a tenant to leave just because you want to rent the property to somebody else. Okay. That's been tried many times. It never succeeds. If a tenant objects to that, or a tenant smells that or gets wind of it, they're going to object to it, even if they move out. And after the fact, the tenant finds out there was an N12 given to me. I was told the buyer needs it for their own family member. It was all a sham. They never moved. Nobody from the family or the owner never moved in. They got me out on false pretense, and then they just rented it out to somebody else at a higher rental rate than I was paying. If that comes up, the landlord and tenant board will not hesitate to charge the landlord that kicked them out with fines and penalties and any other damages that tenant may have incurred, because now they're living somewhere else. They may have incurred moving costs. There may have been other inconveniences to them. They might be paying a higher rent somewhere else than they would have been entitled to pay here. And all those are potential damages that will be recoverable. So never a good idea to be involved or participate in anything like that. Okay, because it will come back and hit you in the face. So let's talk about when the fixed term has ended. In a fixed term, let's say there was a fixed term, parties entered into an agreement to lease or a lease document. They should be using the standard form of lease document in Ontario. And let's say it was for a 12-month period, a 1-year term, and that ends. When that ends, it doesn't mean the tenant has to leave. The tenant becomes a month-to-month tenant if the tenant wants to stay. And remember, the tenants seem to have more rights than landlords to some extent, because the tribunal is always reluctant to kick out a tenant and always prepared to give a tenant more time to find a place. They don't want someone kicked out onto the street. So if a tenant's a month-to-month tenant and a buyer wants to move in or have a family move in, we're back to that 60 days notice that the tenant must move out because the buyer wants it for their own family member. So the seller can, while the seller owns it, can do this on the buyer's behalf, okay, and issue that to get the time ticking on it, okay? But again, they can't use it for false purposes. They can't use it just to try and get the tenant out because they really want to rent it to someone else. So be careful when those N12 notices are being given. Make sure it's completed properly, and maybe you make sure you're completing the dates right and you're giving proper notice. And it does require you in those, if an N12 is being given, that you have to pay the tenant an amount equal to 1 month's rent as compensation for this. Okay, so that has to be part of the arrangement. It's not an optional thing. You have to pay the tenant 1 month's rent compensation if you're issuing an N12. Okay. Now, whoever's providing this, that family member has to occupy it, and bona fide occupy it, and they have to come in for a minimum of 12 months. Otherwise, that N12 is presumed to have been given in bad faith, and there could be penalties and damages, etc., through the landlord and tenant board. Okay, so make sure there's a clear purpose and intention that's really bona fide, that a buyer, whoever it's going to be, the family member is going to need that for their own purposes. Okay, because a tenant that leaves based on that has rights that can extend for a long period of time, and tenants will track it. If they're unhappy about leaving, they're going to keep monitoring to see who's living there, and it's not that hard to figure out. And if they think it's a sham, they're going to come back and claim damages. So let's go over some potential issues that could come up for sellers when someone is selling a tenanted property. The most common issues arise when a seller provides a notice to the tenant and the tenant refuses to vacate by the closing date. So this usually happens when a buyer or family member wants to move in and they're issuing that N12 with the 60 days notice to the tenant. So the sellers agreed to provide vacant possession in the agreement purchase sale to the buyer. And in spite of it, that maybe everything was done correctly and notice was provided, this tenant still refuses to leave the property. So now the seller has to file an application with the landlord and tenant board to end the tenancy and get an order to evict the tenant. Okay, they're within their rights. Landlord's in their rights. Landlord did everything right in this scenario. They gave the proper notice. It's bona fide. Everything was done right. Tenant doesn't leave. So it gets thrown back to the seller. Okay, yet you're in the right, seller, but you have to go enforce your rights against the tenant. You have to go to the landlord and tenant board to get an order to get them out. So first issue is you have to get in. You have to get a date to be heard at the board. Notices have to be given to the tenant. Sometimes these processes can drag on because the board's busy, tenant isn't available on whatever date's proposed, tenant applies to get an extension, things can drag on. Okay, and we know anybody that's ever dealt with the landlord-tenant board or tribunal will know that there's always a backlog. You can't always get in when you want. And I'm saying this from someone who never goes to the board. We don't do that in our office. For those of you that aren't aware, we won't go in front of the landlord-tenant board. It's really a litigation type of issue. Our firm doesn't do that. There aren't a lot of lawyers that actually do that. There are a lot of paralegals that go in front of the board all the time, and that's what I would recommend, that any of you seek the assistance of a paralegal when you actually have to go to the board and apply for an order. And those paralegals are fabulous, better than I could be as to issuing proper notices and delivering them and serving them properly and making sure that all the I's are dotted and the T's are crossed and you're doing it. And they can give really good advice a lot of times about what your likelihood of success is anytime you do have to go to the board, because they're the ones that are in front of the board all the time and see what the tendencies are and what the time restraints are and things like that. So get a paralegal involved. So just keep that in mind. Okay. Now, under the Retail Tenancy Act, it's the Landlord and Tenant Board. That's the only body with the authority to issue those eviction orders that you need. So that's where your enforcement has to go. It's not bringing a claim in small claims court or in any other level of court to get an order. You have to go through the Landlord and Tenant Board if you're going to try and get anybody evicted. So now we're in a position where the sellers got to comply with this, and we have to wait out to get in to be heard by the landlord tenant board. But the clock is ticking because they may have an upcoming sale, and the sale is supposed to happen on April 30th, and the tenant's not out, and we need vacant possession. We need them out, and we don't know if we can get in, get out. So it creates an issue for the closing of the transaction. So seller should take a proactive approach with the assistance and guidance of the seller's lawyer on this, because You're facing a closing date. Time is of the essence. You don't want to be in the breach of the agreement of purchase and sale. So if it becomes apparent that a tenant's not going to vacate by closing, the seller should be telling their lawyer, get the lawyer involved as early as possible, because the lawyer is going to have to reach out to the buyer's lawyer to try and find a solution if there is a possible solution. Okay, and there's different scenarios. Each party has different rights under the agreement. So the agreement says we're closing on April 30th. We're supposed to get vacant possession, but if it becomes factually apparent that's not going to happen, so one possible solution is to see if the parties to the sale transaction would agree to an extension of the closing date. If the buyer really wants the property and the buyer can wait, then they can enter into an amendment either through you guys, through the agents. But at this point, I'd recommend you really have the lawyers get involved, and maybe the amendment is by an exchange of correspondence between the lawyers on behalf of their respective clients. Now, this is the seller's problem, because the seller had the obligation to provide vacant possession on closing. It's the seller's tenant that's not cooperating. And because of that, the seller really needs the extension. So the buyer in this scenario, if they're going to agree to an extension, they're usually going to want the seller to cover costs that the buyer might incur for that, because now buyer's not going to have it on April 30th. It might be a month delay. They might need an extension for a month. So maybe the buyer has to live somewhere else. Maybe they've got to put their things into storage. There might be storage costs. There might be other financial costs that they incur. Maybe the terms of their mortgage will run out, and they have to get a mortgage at the end of May at a higher rate than they would have had if they closed the April 30th. You never know exactly what those costs and expenses might be until you get into the negotiation of requiring extension. But that's one possible scenario and one possible solution, that the parties, meaning the buyer and the seller, can agree to an extension to allow more time for the seller to get the tenant out of the property and close. And let's say they agree to a month's closing and to cover costs. Usually one of the terms there would be, okay, we're going to extend till May 30th because we think we probably need a month to get the tenant out. But if we do get the tenant out earlier, either the tenant leaves on their own or we get an order and the tenant leaves earlier, maybe the parties agree to close and move the closing up and close, a few days after the tenant leaves. So it's just, that should be part of the negotiations on the extension as well. Now, another possible solution is to offer an incentive or an abatement of the purchase price to the buyer. The buyer will close on time and then assume the responsibility of evicting the tenant. In certain fact scenarios, that might be a good option for the parties to consider. Okay, so we can't get the tenant out April 30th. That's our closing date. So you know what? The seller's saying to the buyer, you know what, buyer, close on time. That way you get your mortgage. We don't incur those type of costs. Your mortgage is available. Close on time. You assume the tenant, and you continue with the process of getting the tenant out. So if it takes you a couple weeks, if it takes you a month to get them out, you do that. And because you're going to be incurring costs for getting the tenant out, then the seller is saying, here, I'm going to kick in whatever it is, a couple $1,000, $10,000, whatever it might be, because it just might be a good scenario for the buyer to take over the responsibility, get the transaction closed, buyer assumes the tenancy, and then the buyer proceeds to follow up to get rid of the tenant. Now, if the issue can't be resolved and the seller can't provide vacant possession on closing and there is no extension, okay, so neither of those scenarios happen, those potential solutions, there's no extension agreed upon. And so solution number one's no good. Solution number two is not good for the parties either, because the buyer doesn't want to close and assume the tenancy and have to deal with it regardless of how much of an incentive they were offered. So now we're left to, it's not resolved. Seller can't provide vacant possession on closing. So the seller is going to be in default of the agreement of purchase and sale as soon as we get to that April 30th date. And as a result of that, the buyer might incur some damages because of the default of the seller. So that's what they're facing. So the buyer can certainly demand return of their deposit monies, but they may have incurred other damages as well. Loss of opportunity. They're going back to a different market. Maybe it's going to cost them more money to get another property. Maybe they're going to incur storage costs, blah, blah, blah. It can go on, and the seller could be responsible for the buyer's damages, which is why that gives some incentive to the seller to try and offer up solution number two by providing some monetary incentive to the buyer to close and take over this process, because that might be less expensive, and then at least the seller gets the transaction closed and they're not facing a lawsuit after closing. So bottom line here, whenever you're involved and you get into a scenario where there's a seller that that a seller's selling subject to a tenancy, and there's some an issue with the tenant, and the tenant might or may not get out, get the lawyer involved right away. You need some legal advice to help you guide you through the process to make sure that you understand. And I'm telling you to do this whether you're on the seller side or the buyer's side, because all these things have to be considered and discussed, because there are these different solutions and potential scenarios that could play out. And depending on the fact circumstances, you want to be able to make an informed decision, whether you're the buyer or the seller, about the best way to proceed. So don't do it on your own. As an agent, get the lawyers involved in the process as well. So that's probably one of the most important takeaways for today. So let's talk a little about now. You're going to buy a property subject to a tenancy, but the intention is to assume the tenancy. So I already mentioned to you earlier the importance of making sure that it specifically says that in the agreement of purchase and sale, that the buyer agrees to assume the tenant. And there'll be some sort of description of the tenancy, and the terms of the tenancy should be described in the agreement of purchase and sale. So we need the details of any leases that's going to be assumed. It should be disclosed by the seller before signing an agreement of purchase and sale. Sometimes the best way is to attach a copy of the lease right as a scheduled agreement of purchase and sale, or at least have a summary. Okay, because if you're a buyer, you're going to want the disclosure of it. You can't expect someone to buy something subject to tenancy unless you're explaining to them exactly what the terms of that tenancy is. It's just not reasonable to do that. Okay, so any agreement of purchase and sale should require the seller to provide certain things before closing. Okay, because we're going to need them if you're on the buyer's side. Number one is I mentioned right at the beginning that you should always be keeping the tenant in the loop to some extent. We want to, as soon as it closes, you have to provide the tenant with notice that there's been a change of ownership and a direction to them to make all future payments to that new owner. Okay, so the buyer is going to want that notice to the tenant, and they're going to want a direction to the tenant to make the payments to them as the new buyer. If you don't specify that in the agreement of purchase and sale, that the seller has to provide those on closing, then the seller doesn't have to provide those on closing. Okay, it's common courtesy for them to do that, but there's no legal requirement for them to do it. So put it right into your agreement of purchase and sale. The seller agrees to provide, as a closing document, they'll provide notice to the tenant of the new ownership. The seller agrees to provide a direction to the new tenant to pay future rent to the new buyer. A lot of times that document's done as one document instead of two documents. It might be a notice and direction to the tenant that, dear Mr. Tenant, we closed on April 30th. The new landlord is Joe Smith. Here's his address. Here's where you send your checks and make all future payments to Joe Smith. He's your new landlord. A lot of times that's in one document. Now, another really important document that a buyer wants, if they're required to assume a tenancy, is what's called a tenant acknowledgement or an estoppel certificate. They're really interchangeable terms. And that's a document that's going to be signed by the tenant to confirm that the lease is in good standing, there's no defaults on the part of the landlord, and it confirms the basic terms of the lease. The date of the lease, the rental amounts, whether there's been any amendments to the lease, who pays for what under the lease, whether or not the tenant has an option to buy the property or anything else, or an option to renew or anything else. Anything material should be disclosed in that form. And the reason you want that as the buyer is you don't want to just take the seller's word for it that these are the terms of the lease that I'm going to be assuming. I want to get confirmation from the tenant that what the that his landlord, who's the seller, is telling me about the lease is true, was true when it was signed, is still true, and there's no other issues. Otherwise, the buyer is going to step into the shoes of that selling landlord, assume the tenancy, and after closing, the tenant can say, "Oh, we had an arrangement where I'm going to get free rent for 3 months instead of, and I'm going to fix certain appliances instead of the landlord fixing the appliances, and that was our arrangement. So I'm not paying you rent for 3 months because that was my arrangement." So a new owner never wants to find out stuff like that after the fact. So they want a tenant to sign a tenant acknowledgement or estoppel certificate saying, here's the terms. If there's been any amendments to the original lease, they have to specify what those amendments are in that tenant acknowledgement. If there was an arrangement, because there was an agreement with to waive 3 months of lease payments in exchange for the tenant fixing certain appliances, then that should be specified right in that tenant acknowledgement or estoppel certificate. And if the tenant puts it in there, then the tenant can't come back against the new owner and say, yeah, I have certain rights. And if they failed to put it in there, and after closing, the tenant says, oh, I had an agreement with the old owner that I don't have to pay rent for 3 months. Well, the new buyer can say, sorry, tenant, you don't have the right to insist on that. You should have disclosed that to me in your tenant acknowledgement. Your tenant acknowledgement gave you the opportunity to tell us that your lease was amended by those terms. You didn't put that in there. Therefore, you are stopped from raising that issue. And me as the new owner don't have to comply with that amendment. It's not valid. And that's why it's called an estoppel certificate. Okay, because it prevents the tenant from bringing up anything that they didn't put and sign in that tenant acknowledgement or estoppel certificate. That's their opportunity. So it's a really important document. So a buyer always wants to get that. A buyer doesn't have the right to get that tenant acknowledgement unless you as the agent put something in the agreement of purchase and sale saying that the seller will get a tenant acknowledgement signed by each of the tenants before closing and deliver it by whatever days before closing, so that the buyer and the buyer's lawyer have a chance to review it and compare it to the original lease, compare it to the original, any reps and warranties that were provided by the landlord as to what the terms of the lease are. So we need all those things. The other thing we need on closing is an assignment whereby the seller signs a document that assigns all of the seller's rights and titles and interests in that lease or leases, if there's more than one, to the buyer. So the seller says, whatever rights I have in those leases, I'm assigning those rights to the buyer. You now step in, those leases become yours. You're now the landlord under those leases. So we want an assignment document. Okay, we don't have the right to insist on assignment document if you're the buyer, if the agreement of purchase and sale was silent and doesn't require that the seller provide an assignment of the lease on closing. So make sure you're putting that into your agreements as well. We need all of these things. We need the notice to tenant, we need a direction to tenant, we want a tenant acknowledgement, and we want an assignment of the lease. So if you're on the buyer side, make sure you're putting that in there. If you're on the seller side, there should never really be a refusal to provide any of these things. Okay. The one thing that might be difficult to get sometimes is the tenant acknowledgement if you have a very uncooperative tenant and they may not cooperate to give that to you, and there may not be a requirement in their lease for the tenant to sign that. But you should be considering that up front and seeing if you've got the cooperation and you can do it, because if you can't get that and you can't get that, you don't want to agree that you're going to provide a tenant acknowledgement in the agreement purchase sale when you know that you can't get it from the tenant. And if you can't get it from the tenant, there's other ways to deal with it, and you'll get legal advice at the time, but we might just get a declaration on closing from the landlord, a sworn document to confirm the terms of the lease, and there's been no amendment, there's been anything else, and they'll indemnify the buyer even after closing if it turns out that that was false. And the tenant shows up after closing and say, hey, we did have an arrangement that I didn't have to pay rent for 3 months. Okay, because now it's the landlord that should have disclosed that. And if it turns out that that's true, the landlord, who's the seller, even after closing, can be responsible to indemnify the buyer for that. So there are ways of dealing with it, but it's important that you try and see what kind of cooperation you're going to get from a tenant to sign those tenant acknowledgements even before closing. Okay, and make sure that they're completed fully and completely and properly, and that they're consistent with the terms of the lease. Now, an agreement of purchase and sale should provide for a representation and warranty by the seller that the lease is in good standing, there's no defaults on the part of the landlord or the tenant. And if there are any defaults by either, that should be disclosed. And it should say save and except for whatever. There's a repair that has to be done, or describe it. Disclosure never hurts a party. Lack of disclosure hurts parties. Okay. If the tenant's on a month-to-month lease, you can ask the tenant to sign a new lease, but the tenant's not obligated to sign a new lease. Tenant has the right to stay as a month-to-month tenant. Sometimes it's to the tenant's advantage to sign a new lease. Sometimes it's not. Okay. Oftentimes leases have some prepaid rent or some sort of deposit. That should be a credit to the buyer on closing, along with any interest that's owing by the seller on that. There'll be an adjustment in the statement of adjustment for the current month rent if you're closing in the middle of the month. If you're closing on, even if it's one day, if you're closing on April 30th, then that April rent would have been collected by the seller, but the buyer will be entitled to one day of that rent because the day of closing always belongs to the buyer. So that April 30th day, the rent for that day should be adjusted on the statement of adjustments and be a credit to the buyer. Okay. Now, buyers, anybody that's, landlords are not allowed to increase rents to whatever they want. A buyer assuming a lease can only increase rent if it's been at least 12 months since the last rent increase, and they've got to provide notice of the rent increase at least 90 days before it takes effect. But the government regulates the rent increases that are permitted. And here we've got a couple rates in here. The rate that the government allowed in 2022 was 1.2%. And in the year 2023, the rate was 2.5%. I'm not aware if there's a 2024 rate now, but you can't just do whatever rent increase you want. So any buyer that really is interested in increasing the rent has to be aware and wants information of when was the last increase, because that's material, because you got to, there's that 12-month period has to go by before the next one. You have to give proper notice before it can take effect, and then you've got to follow the government's guidelines as to what the rate's going to be. Okay. And you can never get rid of a tenant just because the tenant's not paying what you think is fair market rent, and the buyer wants to get rid of the tenant because they want to rent it out to somebody else at a higher rental rate. And we've seen examples all the time of attempts to do that. And sometimes they fraudulently use the N12 scheme to say, hey, I want it for my own purposes, family members moving in. But really, it's just a scheme to get rid of the buyer, to get rid of the tenant, because they just want to rent it out to somebody else. These inevitably will fail at some point because they just generally do. So never advise someone to try and do that and take your chances, because you're basically giving advice to your client to commit a fraud and hope that you get away with it. So not a good idea to do. Okay. Now I mentioned, I think already, if a buyer's assuming a fixed term lease, at the end of that fixed term, that lease becomes a month-to-month tenancy. And again, there's no obligation for the tenant to sign a new one. They are entitled to stay on a month-to-month basis unless the parties agree to a new lease, which they could. So there's always an opportunity to negotiate that, but there's no requirement for a tenant to do that. So let's shift gears a little bit. Buying a tenanted property, but you want vacant possession. So buyer's aware the property is currently tenanted. So, but they want vacant possession. So the buyers and you as the buyer's agent, you should make sure that the agreement of purchase and sale states that the seller is going to provide vacant possession on closing. It already says that in the pre-printed form. It says vacant possession will be provided unless there's something otherwise stated in the agreement. Okay. So take a look at that, make sure it's in there, make sure it hasn't been crossed off. If the original lease has not ended, the N12 notification date cannot be before the end of that lease term. Okay, you can't shorten that lease term just because you might bona fide want to give an N12. You can't say, oh, we're closing on April 30th. Your lease isn't up till June 30th, but the buyer wants this for their own purposes. So we want you to get out before your lease ends on June 30th. You'll never succeed with doing that. So you have to give the 60 days notice, but you can't shorten the term that the tenant is allowed to have under their fixed term lease unless the tenant agrees otherwise. And if you give the tenant incentive, they might agree to something, but you can't require it, and you've got to pay attention to those dates. Okay, so you take a look at that. You want to know, you want to make those inquiries if you're acting on a seller, or if you're on the buyer side, you want an increase of the seller's agent before signing agreement for purchase and sale to try and figure out the timing of this. Is the lease under the original term? Did that term already expire? Are they now on a month-to-month? Because that determines when you can actually get rid of the tenant. So you've got to be calculating from the appropriate dates for that. So if the tenant is a month-to-month at this, you can ask the seller to provide that 60 days notice on the buyer's behalf. It's the buyer that wants the property for themselves or their own family member. So you can ask the seller to issue that notice that, hey, we've got a buyer needs it for their own purposes. They're going to move in, or their family members can move in. Here's the N12 form. Okay. Now, the agreement of purchase and sale says that vacant possession to be provided on closing, but it would be prudent to spell out exactly what the arrangement is here. So you'd want to put in the buyer should specify that the buyer or a family member will be occupying the property on closing and require the seller provide the tenant with the N12 notice. And then you want to get evidence that, in fact, the seller provided that N12 notice. So you'd want a copy of it, and you want some evidence provided as well that was in fact provided. Because now we're trying to get the tenant out, and we're trying to get them out in time to close because the buyer needs it for their own bona fide legitimate purposes. Okay. Now, if the timing doesn't work and the closing date is less than the notice that's required to be given, the buyer is going to be assuming that tenant until the end of that notice period. So we can still close the transaction, but if the notice period doesn't run out till May 15th and we're closing on April 30th, the tenant's going to have to leave on May 15th, but we're closing our transaction on April 30th. So now the buyer has to assume that tenancy. So we've got to be calculating all these things in advance, because the buyer is assuming it. Then we're back to that scenario. Well, what if, okay, we close, we know the tenant has to get out by May 15th because we've given a legitimate N12, but now what happens if the tenant doesn't? Now it's the buyer's property. Buyer's got to go and try and get an eviction order and incur that. So we always want to be calculating these things up front to figure out what the timing issues and who's going to pay for what costs if they're going to be incurred. So that's obviously not a great scenario for a lot of buyers to close, and then 2 weeks later they're hoping that the tenant actually vacates, and if not, then the buyer's got to take action. Sometimes we're back to that scenario where it might be better for the buyer to say, you know what, let's move our closing date till the day after the tenant is supposed to leave on May 15th. Seller, it's still your obligation to get them out, and you do it. And if you don't, you're going to be in breach of the agreement, and I have rights, or maybe I'll agree to an extension to give you more time to get the tenant out, and you cover my costs, and you go back into that type of discussion. Now, let's talk about a partially tenanted property, and we deal with these type of scenarios all the time. The buyer is assuming a property where the tenant isn't occupying the whole property. So the tenant's occupying one part of the property. Maybe it's a detached house and you got a tenant in the basement, and the buyer is going to be moving in upstairs. So we're getting vacant possession of the upstairs, but it's going to be subject to a tenancy because of the basement apartment. You have to make sure in your agreement of purchase and sale that this is clearly described in the agreement. Okay, we're not getting vacant possession. We're getting vacant possession of only part of the property. We're getting vacant possession of the upstairs, or however you're going to describe it. Maybe there's more than one unit in there. You're getting vacant possession unit 1, but we're not getting vacant possession unit 2. The buyer's going to assume the tenancy on unit 2. So the agreement has to specify which part's vacant, which part's going to be subject to tenants, and then anything that's going to be subject to tenants, everything else that we've already talked about in this webinar is going to apply. We're going to want that notice of direction to the tenants. We're going to want a tenant acknowledgement. We're going to want an assignment of the lease, etc. We want to build all those things in those scenarios too. Just because we're getting part of it vacant and the buyer might be moving into that part of it, there's still a tenancy. We still want all those other things, and make it clear what exactly the buyer is going to be assuming, what tenancies are going along with that, if you're in that scenario. So to conclude, whether the seller is listing a tenanted property or the buyer is thinking of buying a tenanted property, always a good idea to consult with a legal professional who's familiar with residential tenancies before proceeding with a firm deal. I'll take this one step further. Oftentimes we want to bring in that paralegal who goes to the tribunal all the time, because they can provide valuable insight that most of us dumb lawyers just don't have when dealing with residential tenancies, because we in fact don't go in front of the tribunal. So you can ask me questions about it. I'm sure I'll get some of them I'm just going to not have the answers for. I don't have a feel, because it's a moving target as to the timing of when you do have to go in front of the residential tribunal board, how long it's going to take to get in, what type of decisions they're making. We do know there's always a slant towards the tenant. They never want to kick out a tenant, especially when you're in the middle of winter months and it's cold out there. They're always going to give a tenant more opportunities, issue an order. Even if they're issuing an order to evict, they're going to give them the benefit of the doubt more often than not. And they're going to ask them, how much time do you need to get out of your property? And if a tenant says, I need at least a month, I need 6 weeks, they might still issue an order requiring to leave by that date, but it's going to be a longer time frame than the buyer or seller really wanted. So you've got to anticipate that. And if you're going to get into any of these scenarios, that's why I think it's a good idea to get a paralegal involved to find out from them, like, what's a realistic timing and what type of orders are you seeing that are given, because you want to structure your extensions or your closing of your agreement purchase and sale in accordance with what the reality might be if you have to go in front of the tribunal. So make sure you get proper legal advice, and the legal advice would go along with not just the lawyer, but a paralegal being brought in that's familiar with going in front of the landlord and tenant board as well. So with that, I'm going to pass it back over to you, Sabiha. I assume there might be a
Yep,
question or two that people want to raise.
sure. I'll start with a bunch. Do you have any paralegals that you often work with that you can give us, maybe share a list with us? Because I've always found this challenging. We do find paralegals, but they're not very responsive.
Yeah.
So it would be good to have a few names on our panel.
Yeah, I'll send you what I have. I've got 2 or 3 that I refer people to. I never, well, I don't not say never, but I often don't hear back afterwards which one they end up retaining or how good it was or how bad it was. Um, Sometimes they don't use the referrals that I sent. So they might find referrals from
Right.
other sources. So I never really know, but I'll give you the few names that I do have.
Perfect.
Um,
Thank you. Because this is very helpful. Because, guys, it's more important than not that we pay attention to this, because at the time of closing, when tenants do not move out, then you have a huge big issue. And very small things like the filling out the N12 and how accurately it needs to be filled out. Otherwise, it's thrown out for simple reasons like the middle name was not spelled correctly, or the commencement of the dates was not matching. It was a day short or whatever. And at the end of the process, you can find yourself in that position where the N12 was completely thrown out by the tribunal board.
and Sabia, you're 100% right. They're looking for any clerical mistake on a form to
Yeah.
say, oh, tenant wasn't given proper notice because they mixed checking off a box on the form, or they, the wrong postal code, there was a mistake, a clerical mistake. They're looking for that. And if they find anything like that, they throw it out. They say, no,
Mm,
you have to start over again, issue another proper N12, and now the 60-day clock starts to run brand new. So
hmm.
even if there's no prejudice to the tenant, usually they don't care. No, we found a defect, start over again. So that's why, you get a paralegal on board and make sure that they're taking over responsibility for completing that, and that they're serving the notices properly.
Right.
Okay. Because you need
Um,
evidence, not only that you're giving notice, but you need some evidence. You need proper evidence that the notice was served properly too.
mhm. Absolutely. J just a clarification on something that you had mentioned, that is there absolutely no way that within the rental period, the 1 year rental period, can the landlord give a notice for the the tenant to leave the premises prior to the lease end?
Sorry, repeat
So
that.
if so, you know how you said that the during the rental period, the tenant cannot be asked to leave the premises. So is there absolutely
Right.
no possibility in any which way? And
No,
does it work both ways?
there's always a possibility.
Mm,
Okay. There's no legal right to require the tenant to
right.
go to leave early. Um, you can negotiate with the tenant and come to terms that, you have the right to stay till June 30th. We want you to leave on May 30th, and we're going to make it worth your while. Here's what we're prepared to offer you. And you negotiate something, and then they enter into an agreement to end the tenancy early, that an 11 form. Okay. And then you have
Mm,
something that you can enforce. But the tenant doesn't have to agree to anything. Like tenant
right.
doesn't, they can just say no, 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 no matter what you're offering. They can continue to say no. And you're not going to be able to go to the court and convince the tribunal, we're being really reasonable. We offered them, 10 grand to leave a month earlier, and they're saying no. So we want you to issue an order requiring them to leave a month early, and we'll give them the 10 grand. You have no chance. You're never going to get that type of an order. They're going to say, no, they have the right to stay till the end of June. You got to wait till the end of June.
Right. Um, I know that we had this conversation on our Monday coffee, and Nader had brought up that article which I had forwarded to you. And you mentioned in your response to that, guys, whoever was on the Monday morning meeting, Nader had brought up this article. There was a judgment against a tenant for the HST that should have been held back, or the taxes, sorry, not HST, the taxes should have been held back by the tenant, because the landlord was a foreign resident. And it was established that it was 25% over a 6 year period that they became liable to pay CRA, because the landlord was a foreign investor. They did not hold back that amount of rental. They were giving the whole amount to the landlord. And eventually the court found that the tenant responsible for paying CRA, this whole big huge amount. Um, so here's, David, your response was that Form 400, which is the agreement to lease, Section 16, is already taking care of that.
Well, to some extent, okay. Now this is the pre-printed form.
Mm-hmm.
I don't know if I have it. Let me see if I can. It'd be worth. I don't know if you have it in front of you.
I can pull it up super quickly while
Yeah,
while
this.
everybody's
Yeah, please do that. So, this is an absolute absurd decision, in my opinion, by the government, by the CRA to do. So, what happens here is a landlord becomes a non-resident of Canada, and as soon as they become a non-resident of Canada, then there's an obligation on the tenant to withhold some of the rent, the same way that there's an obligation when a non-resident sells real estate in Canada. We have a withholding tax, the Section 116 withholding tax, which requires a holdback of a portion of the proceeds in case the non-resident seller owes some tax to the Canadian government. And they impose that obligation on the buyer of the property. So if the seller owns tax, but the seller's a non-resident, the buyer is responsible to pay that tax. Therefore, the buyer will require that there be a holdback of 25% or 50% of the proceeds on closing because of that. Okay. So, and that's the way we close transactions. So we do have that holdback. But in this scenario, we've got a landlord that becomes a non-resident. Okay. So the what the clause is, and it's clause 16 that Sabiha has put up here, the residency clause that's in the pre-printed lease form. It says the landlord shall notify the tenant in writing in the event the landlord, at the time of signing this lease agreement or during the term of the tenancy, becomes a non-resident of Canada. And if that happens, if the landlord becomes a non-resident, then the landlord and tenant agree to comply with the tax withholding provisions. So this is saying landlord is saying, probably time of signing the lease, I'm not a non-resident right now, but now you've got a 12-month lease. 6 months later, the landlord becomes a non-resident. So the landlord is supposed to then provide notice to the tenant, oh, I just became a non-resident, therefore we have to comply with the Income Tax Act, and it's subject to the withholding provisions. So therefore, withhold 25% of your rent, because that's my obligation, because I might have to pay that money to the government. So that's great, okay, that we've got that in there. So now we've got landlords saying, I'm not a non-resident. If I become a non-resident, I'll let you know, and then you start withholding money. So the problem I have is, what if the landlord doesn't? And I think that was the scenario in that case, Sabiha. The landlord became a non-resident, didn't tell the tenant. The tenant had no idea the landlord became a non-resident, had no way of knowing. The tenant just kept paying their rent like they always do. And the CRA comes after the tenant saying that your landlord became a non-resident. You were supposed to withhold money from your rent. You didn't. Therefore, you're responsible, Mr. Tenant, for paying that money to the CRA. Even though you paid your full rent to the landlord, in addition to that, you have to pay the CRA the amount that you should have withheld in order to satisfy the taxes that are owing by the landlord who's living in some other country, because the CRA knows they're not going to collect it from the landlord. It's totally absurd. And I was surprised to see that that's what the CRA came up with, because you have no way of, if you're a tenant, you have no way of knowing if your landlord becomes a resident or doesn't become a resident. It's almost an impossible situation to deal with. So I'm not sure if this is going to continue, or if CRA is going to look at this, or governments, when people start screaming, are going to say, like, this can't be right. We can't really impose that obligation on a tenant. If now it's clear, if a tenant does get a notice from a landlord, fine, that's fair game. Okay, landlord provided notice, I'm now becoming a non-resident. So go ahead and withhold some of your rent. So that's fine. And if the tenant doesn't do that after they receive that notice, that's fair game for the CRA to come after the tenant in that situation, but not in a situation where the tenant had no knowledge that a landlord became a non-resident. It just seems like an absurdity, but
Yeah,
that's the
very
law right
apparently
now.
right. So that's what the tenants was saying, that I had no knowledge of this, but the judgment was still against, sorry, the judgment was still held against the tenant.
Yeah. Which, so that's the CRA saying, I don't care. I know I probably won't be able to collect from the landlord, so I'm going to collect from the tenant, even though it's absurd. And the tenant can go and chase the landlord instead. If the tenant can find the landlord and collect from them, good luck to them. But it's never going to happen.
Mm,
So it just doesn't seem right. But that's the way the law has been interpreted right now on this. And I'm not sure how to deal with it. Like you've got this clause in there that requires a landlord to let a tenant know if they become a non-resident. But how do you close that loophole if the landlord just doesn't? And the tenant has absolutely no knowledge or no way of knowing that the landlord left the country.
right. Um, Victoria, you've asked a question. I'm not understanding it. So if you want to unmute yourself, please
How are
do.
you?
Hi. Good.
Yes, I have a question. I'm dealing right now with a situation with the parents of my client did the landing to Canada. So they want to move to one of my client's condo. So my client is issuing an N12. So yesterday we called the landlord and tenant board and they told us first, if we have the SFL signed and notifications can be done by email, we can serve the tenant with an email attaching the N12 form. That's my first question. Is that correct? Or I need to serve the tenant?
I'm not sure the answer on that one. That's where we get into what's considered proper service, and you're better off getting that type of answer from a paralegal that
Yeah,
does
that's
serve those
stipulated
things.
in the standard lease form, Victoria.
Yeah, the standard list form, it says like we can use the email for daily communications. So when I call the landlord and tenant board, I asked them, do I have to serve them or can I send it by email? And the response was, if you have something in writing that says that you can have communication by mail, you can use that.
Yes,
But
like if the notice clause in the lease says that notices can be provided by email to this address, then yes, you can provide notice by email to that address.
not on the list, on the standard list form.
On
Yeah,
the
That's
lease form.
that's considered the
That's the
lease.
lease.
Yes,
The
that's
standard
the
lease form
lease.
is the lease.
okay. The second question that I have is like yesterday when we were having this conversation, the parents were there, and the parents are like, "Oh, we don't know if we like Toronto. What happened if we don't like Toronto?" Then my client told me, "Oh, we will sell the unit, but at least go there and give it a try." It's like, oh, my question is, what happened if after 9 months they hate Canada and they want to go back because they miss the help and the mates and everything, and my client has the property vacant? Do we have to keep it vacant for the next 3-4 months until we comply with the 12 month, or we can put it for sale?
Yeah, well, first of all, if they leave after 9 months, then even if it's vacant after that or not, then they didn't fulfill what they're supposed to fulfill by issuing the N12 in the first place. So that tenant that left in reliance on it being a valid N12 given to them, and if they did suffer damages and they find out that the parent only stayed there for 9 months, they can try and collect those damages against them for being wrongfully evicted from their property. Okay, so there is that risk to them. So they shouldn't be issuing an N12 unless there is a bona fide intent that they're going to be living there for at least a year, and the evidence better support that they actually moved in and stayed there for a year. Otherwise, they could be subject to damages if the tenant that left finds out that that they didn't comply, and now they're out and maybe they've suffered real damages because they had their moving costs, they had to put stuff in storage, they had to lease another property that cost them a lot more money than this place, and they would have had a right to stay. So they may have suffered real damages. So there's that risk to your clients if the terms of the N12 can't be complied with.
Okay. So for this particular scenario, do you recommend us to use a paralegal or just the landlord serving the tenant by email? Because it's true, the parents are moving in and we have an open communication by email. We offer the extra month for free. And we tell them, if you need a letter of recommendation, we can give it to you. My parents are already here, and like the last day will be the 60 days of the contract.
Yeah, I generally think it's worth having a paralegal involved to make sure that the N12 is completed properly, make sure the notice is served properly. There's evidence of the service that's available in case they have to go to court, that they've got all their ducks in a row and everything was done properly. Paralegals, I can't quote you what their rates are, but it's far less expensive than a lawyer's hourly rate, and maybe you need a half hour of their time, maybe you need an hour of their time. It could be a very worthwhile investment to have that consultation and make sure everything is being done properly, and it's set up, and you're setting it up and giving the notice defensively in case you do everything properly and this tenant still doesn't leave and you have to go to the tribunal. You want to make sure that everything was done exactly properly so that you can walk in and get an order from the court saying, here's everything, here's the notice, it was issued, here's evidence that it was served properly, and then you're not going to have it thrown back at you by the tribunal saying, no, we found a defect here, you got to start over and issue another notice.
Perfect. And yeah, Sabiha, can you please send us the names and contacts of the paralegals?
Yeah, I'll send it, what I have, to Sabiha, and she can forward it on.
So Jay's asked, what if the seller gives the N12 60 days notice as per buyer's instruction, but the tenant doesn't agree to move out? I think David has explained that already, but yeah, it's a big problem for the seller then at that point.
Yeah, you have to try and enforce the right to get the tenant out, but on the other hand, you have to take into account what the parties are going to do about that, because you're going to have a time issue, and parties either have to agree terms of an extension like I discussed before, or they close and the buyer takes over responsibility, those different scenarios, or the agreement falls apart because you can't provide vacant possession. So you've really got those three scenarios, and you're going to have to try and figure out which one is going to be agreeable by the parties.
And also, I just want to mention, guys, whatever you put in your schedules, it can be thought out clearly. You know already that might happen where the tenant doesn't leave, right? So you have to just make sure that number one is hopefully that the buyer will agree that if there is a delay, that you just commit to giving the notices. But after the fact that the notice is given and the tenant has a delay in moving out, that the buyer will take the responsibility of the tenant till the tenant actually moves out, right? You can also have like a slightly delayed closing option in there in case the tenant doesn't move out. Both parties agree that the closing may be extended for another 30 days or 60 days for that to happen. So just foresee all of these issues that might arise in a tenanted property and take the consultation of a paralegal to make sure that at the end of the day, your deal is not completely botched and there's big trouble for your seller clients.
Hello, everyone. If I can just just add it up to it. Usually what I do with N12 or if the tenant gives an 11 or whatnot, I give right away the L forms as well, which comes with eviction. A lot of times, for example, the tenants go like, "Oh, why you evicting me?" I'm basically not evicting. I'm basically, especially when I'm selling the property, it's not like another tenant is moving. It's when I'm selling the property, I'm preventing another 60 days, for example. So once the N12 stops being in effect, the day after, instead of giving them the L form, which is the eviction, it's the application is already there. So for that 60 days or that 90 days, it's already in the process, just in case if they don't leave. The process is a lot faster because it's the 60 days backwards kind of going, if you know what I mean.
Yeah, so you're already providing you're already bringing an application to get a hearing date.
Yes, because it's $180 or $200, but at least I know that if I have a buyers that are closing on the same day or the day after when the tenant is leaving, I already know that I already have backwards 90 days or 60 days. And then I can get the hearing already much faster because I'm already in the line, kind of.
Yeah.
Yeah, and that actually is there in the vacant possession clauses that we have, guys. So you can use this clause here, and it already talks about if you are representing the buyer, then you can put this in the agreement where there's the N12 is accompanied by the L2 application.
Yeah, no, that's a great clause to use.
Yeah.
Good point. Thank you.
All right. Thank you, everyone. Thank you, David. This
Thank
was great.
you.
Thank you. And we'll see everybody next time. I'm not sure what our next one is.
Yeah, I think next week.
I don't think it's next week. It might be the week after.
The week after, is it?
Yeah, I think underused housing tax on May 2nd.
Okay.
Yeah.
Perfect. All right.
Okay.
See you all.
Thanks, everybody.
Thank you. Bye.
Thank you.